And we'll go ahead and get started. Yeah, I think we have a great topic for you today. It's one that is, I feel is evergreen. It's one of those things that there are always changes. There are always situations that change in your life that maybe dictate an update of an estate plan. And Scott is a great speaker, a great teacher, and I think we're going to have a lot of good things to cover with you today. Before we do get started, let me just go through a bit of an introduction of Cornerstone. You probably saw these invitations come out and you see these invites from Cornerstone, and you might be thinking, well, who in the world is this? My advisor is not with Cornerstone, or at least they don't brand that way. And I just want to give you a bit of an introduction to who the firm is. The firm was founded in 2005, based in St. Louis, Missouri. We have 131 advisors scattered across 15 states. Little over 9 billion in assets under management, although I will say the last few days have been a little challenging. So hopefully we've stayed above that threshold. We'll see how that is at the end of the day today. And we serve over 54,000 individual clients through those 131 advisors that I mentioned. Now, I said before that you may have no idea who Cornerstone is, and that's because your advisor may brand is something entirely differently than that. And you'll see our two main brands up at the top, Cornerstone Wealth Management, Cornerstone Wealth Services. But your advisor might be with LifeMap Wealth Management, or they might be with Vine Wealth Management, or Ginfinity Wealth Management. These are all brands that our advisors have chosen to use, and we fully support that. All of our advisors are clearing through and use as a broker-dealer LPL Financial. If you're not familiar with LPL, this is the company that sends your statements to you. But in a lot of cases, people don't know them all that well. But the firm actually manages all in over $1.7 trillion in total client assets. There are over 28,000 advisors across the country who use LPL as their back office and broker-dealer. But I think one of the most important numbers you see or statistics you see on the screen there is zero, and that is zero proprietary products. The firm is not pushing the advisors who affiliate with them to sell any particular product or service. It's really just focused on doing what is really the best for the client. Now, how does this all fit together for you? Your advisor obviously has set up an independent financial advisory practice to serve you. They've partnered with Cornerstone to provide some additional structure, support, and scale that they normally wouldn't have on their own. And of course, they use LPL as their broker dealer to provide that back office support, product availability, and so on. But some of the support they get from Cornerstone is things like this webinar. We've found the speaker. We went through the compliance process of getting the invitations approved, the presentation approved. And all the advisor really has to do is push that out to you in the form of an email, which gives them and their practice more time to really focus on you and just give a higher level of service. And really, that's what it's all about. Now, at the end of Scott's presentation, we will have time for Q&A. The chat function in Zoom is not functional, so you can't do it through there. If you do want to ask a question, you'll have to email that to cornerstonewm@lpl.com. No dots, no spaces in that first portion of it. It's just cornerstonewm@lpl.com. That email will come to me, and then I will ask Scott the question. So let's go ahead and get started. Scott, I'm going to stop sharing my screen. You're welcome to start sharing yours. But as I said before, Scott Keifer is going to be our speaker today. Scott is an attorney at law with St. Louis Estate Planning. He's also the founder of St. Louis Estate Planning. And we've had Scott on before on these webinars. It's always one of our highest rated webinars that we do. It's great information. Scott has a fantastic personal story that he shares as well. But I think what you see on the screen there really says it all. It really takes a very complex issue, and he does a great job of simplifying it into terms that we can all understand and then apply in our daily lives. So Scott, really appreciate you being with us today. Please take it away.
Thanks, Bill. Appreciate it. And you can see the screen, correct?
Yes, we're good to go.
And let me make sure you're going to get it changing. Hold on. Changing.
Yep.
Perfect. Okay. All right. I'm gonna start quickly by thanking everyone for being here, and acknowledging that you've you've chosen to come to a topic which is the world's worst topic, right? We're planning for death. We're planning for your death, and it's the worst. And if you pay attention today as we go along, I'm not just killing you off, we're going to kill your spouse off in our discussions, and we kill your kids off. If you don't have kids or don't have nieces or nephews, we're going to give you some in the discussion, and then we kill them off too. And it's, but I promise we're going to do it in a light way. And there's a reason you're here. It's because you care about people, and you could do what a lot of people do, which is nothing, and you just leave a mess, and the people have to clean it up, and they will resent that. And I have seen it, and I've seen them curse their relatives and go, why did they leave me this mess? But it is a bit of a sacrifice for you to be here today. So I do want to tell you that we appreciate it, and your family will appreciate it also. Um, Also, I want to throw this out. While you are here to learn about the worst topic in the world, I have the greatest job in the world because I get to help people. And you are more than welcome. My contact information is at the bottom. You're more than welcome to call me or email me if you ever have questions in the future. I love helping people, and I'm thrilled to be here to do it. So reach out anytime. So we are going to hit 4 topics today. On a road trip, I like to have a map, and so I'm going to give you a map, and you'll know exactly where we're at as we're moving along and how long it takes to hit each one. We're going to hit the basics of estate planning. We are going to do it in a way where I'm confident that if you do not know how it works, you will in about 20 minutes. And then we're going to get to section 2, where we all go through life and step in some piles of dog poo, and I want to identify the other ones other people have stepped in, so you don't have to do it. And I'm going to have 2 handouts that I'm going to show you on slides, but you can get those from your financial advisor. I'm going to send those to Bill as soon as this is over. And I think Bill said it has to run through compliance, which will take a day or two, and then it will be available to your financial advisor. But I think you will find both of those slides very helpful. So I really do encourage you to reach out to get those. So that's going to be part 2. Then we're going to go on to just a couple minutes about what happens when your kids or grandkids are between about 18 and 25 years old, because no one thinks about it. And then we're going to wrap up with my personal story, which is something that I guarantee, if you don't know my backstory, you've never heard another attorney tell you, because I've been a lawyer for 27 years and I have only been telling people it for the last 3. So if you start losing focus or nodding off, just hang out for the last 5-6 minutes. I think you'll gain a lot from it. All right, first topic, estate planning simplified. I've been doing this similar presentation for years, and I would go into a number of slides about estate taxes, and you're going to get the 1-minute summary of it. Basically, if you have less than $14 million right now, there is no estate taxes. And a married couple can pass twice that. But the reality is we have absolutely no idea what's going to happen later this year or next year or 5 years down the road. And in my career, there's been very few times where I have felt that way. The Republicans have put some bills forth that have said they're going to permanently eliminate estate taxes. That's entirely possible. It's also possible that in 4 years, the Republicans are out and the Democrats are going to reinstate them. So I am not going to waste your time talking about them. I will tell you that if you have more than 14 million, you definitely need to be talking to your financial advisor about it. And if you have more than a few million and your spouse dies, you absolutely need to be talking to your financial advisor. Other than that, we're not going to worry about it. I put a map up here of states that have estate or inheritance taxes. If you are in a gray state, you do not need to worry about it. And if you are in the other ones, most often the taxes are not that high anyway, but there are mitigation techniques you can do. And so you even have more of a reason to go get your estate plan done if you're in one of those. Let's talk about wills. My expectation is that your understanding of wills is wrong. Most people's understanding is wrong. Most attorneys' understanding of wills is wrong. Clients will call me all the time and they will say, I need a will. I need a will. And we floor them when we say, hey, your goal is to never use a will. It's not because you're dead. It's because, very simply, your will is your instructions to a judge, your instructions to a court. Wills only work in court. And you don't want your family going to court if you're gone. Because when they go to court, it is slow. It is 8 to 12 months if everyone's getting along. And that is the worst thing you can do to your family, is force them to go into a situation where they are expected to use a will, a legal document, to go in front of a judge for 8 to 12 months. How expensive is it? In most states, the rule says reasonable fees. Missouri is taking a different approach. Missouri says, we'll tell you what reasonable fees are. And here's an example. Here's a table. In Missouri, it goes all the way. It's a math formula. And let's just circle one, a $500,000 house. If you have a $500,000 house in Missouri and you've never done an estate plan, you've never put a transfer on death on your house, and you die, go to the right there. The court will automatically pay out $14,050 to your executor if they want it. It'll probably be one of your family members and they will waive it. But go further to the right. There's not an attorney in town that's going to waive their fee, so you're going to spend $14,000 there. So between an attorney fee, an executor fee, you're also going to have court costs. You're going to possibly have bonding fees. You're going to spend between about $15,000 and $30,000 to get a house through probate. So when people say, I have a will, I have everything in order, no, you have a will, you have instructions to a judge. That is the last thing you want to do to your family. So clearly, we want to avoid that, and so there's only 3 options. Number 1 is a universally terrible idea that widow moms do all the time because they're told to do it by their friends, they're told to do it by their banks. This would be you add one of the kids on the account. And it goes like this. And my mom did this with me. She calls me about 2 months after my dad passed away, and she said, I'm up here at the bank. And she said, I'm going to put you on my checking account. And I said, oh, no, you're not. Now, what the bank wanted her to do is say, hey, this will be your son Scott's when you're gone. But what I said was, Mom, if I get divorced, my wife could take your account. If I get sued, they could take your account. If I file bankruptcy, they can take your account. It is extremely risky to put other people's names on your bank accounts. We work with about 8 clients a week, and we go through the same dog and pony show with people, and probably about 25% of them give us the same look and go, my daughter's on my account. It's all the time. So if yours is on there, don't feel bad. You are at risk in that situation. Your daughter's bankruptcy, divorce, lawsuits. Okay. It skips probate. If your will says my bank account to my church, it isn't going there. It's your daughter's account. It's going there. All right. Our option 2 is a free estate plan that people do all the time, and your LPL advisor is probably doing it on your accounts, which is just adding a transfer on death, pay on death, beneficiaries. 3 phrases, same thing. We're going to cover that here in a second. But before we do, let's talk about our 3rd option, which is a trust. Picture a trust like a bucket. Everything you own falls into the bucket, and we're going to talk about that in a minute. So 3 options. Put someone else's name on the asset. Bad idea. Option 2, adding people as a transfer on death. Not always a bad idea. And the 3rd option is build a trust. It's like a bucket. We're going to talk about 2 and 3. Transfer on death listings. This is your plan when you don't do a trust. It is easy. It is inexpensive. And when I say inexpensive, it's basically free. You tell your LPL advisor who you want to get your account. You tell your insurance agent, right? We can do a deed on your house. It's very inexpensive. We can file it in your county and it says it's your house. If you're dead, who it goes to. Here's your potential problem. It usually works fine. And I have that highlighted because the word usually is super important. And when I say usually, I might mean 95%, 98% of the time. But when it fails spectacularly. And I mean terribly. And we're going to go through some examples. All right, in this example, I always kill dad off first. So this is mom still alive. Mom's got a bank account. She's got her investment. She's got her retirement along the top, her life insurance, her home, and she's got a small business. And she's got, you can say she's got 5 kids. You can say she has 1 kid, but we're putting 5 different scenarios for the kids. Doesn't matter. The arrows are the transfers on death listing. She sets up on everything where she's at, and she thinks she's fine. But let's go through the problems. And remember, these problems don't hit 95% of the time, but when they hit, they're spectacular. The charities would love your money. They really don't have the ability, 1, to know you're dead, 2, to know they're listed, and 3, to go collect the money. They would like someone to send them a check. They just don't have the ability to go and go collect that money. So generally, they prefer for someone else, like a trustee, to be listed, just to write them a check. There's some exceptions, but you do need to be careful on that. Let's go through our 5 potential beneficiaries at the bottom. When you give your money, person number 1, when you give your money to your daughter at the bottom, it very quickly becomes hers and her husband's. You may love your daughter and your son-in-law. You may not love him. But the reality is, she puts it into a joint account. They write checks out of it. It's theirs. And he leaves a year later, and he's going to take a big, big chunk of it, if not half. And so there's very little ways around that if you list your child directly. I will tell you this, in Missouri, if you give your home to your child, it is absolutely 100% your child's and their spouse's. That house will never be sold without their spouse's consent. We had a client who came through. Mom had died, and she listed her 8 kids as transfer on death on her house. She filed a deed years before that listed all 8 kids. And they were horrified when they found out that all 8 kids had to go to the title company and the 8 spouses. And I said, I hope everyone's in a good marriage. And they said, 2 of them are going through divorces. I said, well, it's going to be real tricky to sell mom's house because you now have 2 very unhappy daughter-in-laws who are going to hold up the sale of that house. And they did. So I'm unsure how that works in other states, but I know in Missouri, when you list an individual as the owner of a house, their spouse also owns it. Go to person number 2. Sometimes people don't die in the order you think they're going to die in. And you list your beneficiaries on accounts years ago, and maybe they pass away, and before you update your beneficiary, you die, and a little child inherits. It's not a great situation for a 2-year-old to inherit $1 million. A court will be involved. That money will be theirs at 18. Person number 3 at the bottom, there are no controls you can put on money going to somebody when you give them money directly. It's just theirs. If they want to blow it all on drugs the next day, they can do it. Number 4 here, there are certain people who are better off not inheriting because they're already receiving some benefits either from the government or other locations where they will lose those benefits if they inherit directly. And you have to be real careful about not making their situation worse by giving it to them. And so just a consideration. Number 5 here, we will see people come across and they'll list their grandkids to get their money. Well, when I say, are you okay with your grandson getting $500,000 when he's in college? They say, oh, no. I said, well, you've listed him getting 1/3 of your assets. So transfer on death, there's no restrictions you can do. You list them, it's theirs. So people say, hey, I have all my transfers on death set up. Why do I even need a will? I don't need one. Okay, fair feedback, but there are 2 reasons. Number 1, in Missouri, and I believe in a lot of states, and remember, I'm only licensed in Missouri and Illinois, so I can't speak in other states, but most are very similar. In Missouri, a will is the only document where you can name who's going to raise your kids if you're gone. If you or your kids have minor children, it is absolutely the reason why you want to have a will in place. You want to make sure that you have say in who's going to raise them. Number two here, this is our big one. People are often wrong, and I mean often wrong, in what they believe is the nature of the assets they own, even when they're dying. I had a in-your-face example of this. I met a man that I have known for 40 years. He was my neighbor, a wonderful human being, and I met him on December 17th, and he was terminally ill. And we went through every asset he owns, his bank accounts, his home, his farm property, his investments at LPL, everything he owns, and made sure he had the proper transfers on death listed. And he told me everything was in order. We believed him, and we did a will anyway to make sure. Because remember, a will is your plan for things that do not have a transfer on death. About 6 weeks after he died, his family called and said a couple $100,000 worth of savings bonds, which were bought in the 1970s and are fully mature, were found in his office at home. What did they do? Thank God we did a will. We have now started a probate process, which is going to take about 8 to 12 months. We're going to get the assets where they're supposed to go, but without the will, it would have been much more difficult and much more complicated. So, all right, let's talk about our last option, right? So you could list people as transfer on death, or you can do a trust. Those are really our only two good options. Now we're up to the trust. Picture a trust like a Home Depot bucket. It is no more complicated than that bucket. And I hope next time you go to Home Depot and at the end of every aisle, there's a stack of buckets, and I hope you think of me. Those buckets collect, manage, and distribute the assets in the way you want, and they skip probate. The trust always allows for contingency planning. The people who set it up can always change the rules. After the person who sets it up's death, the trustee, that's the person who is appointed to manage it, is required to follow its terms. But it's not that complicated. And one of the things is, it is a private transfer. It's a beautiful thing. Anything going through probate is public record. Someone you dated in college can find out how much money you have. Your nosy neighbor can find out how much money you have. They can't with a trust. And trust can plan for almost anything. We've worked with 4,000 clients over the last 10 years, and about 95% of them go with a trust when they learn about the great protections it has. And the next question they always ask, what's the drawbacks? I want to know the drawbacks of a trust. And there's two. Everything has drawbacks. Number one, people don't title their assets right, especially when they do the estate plan on their own. They go onto the internet and they do a trust, and it says, first line on the trust, I've seen it. By establishing this trust, I hereby move all of my assets, my house, my bank account, my investments at LPL. I move everything into it. It doesn't work that way. So I tell people, after mom dies and she did her own trust and she didn't title anything right, I say, well, your mom built a bucket. The law recognizes the bucket she built, but it's empty, right? It's kind of like there's nothing in it. So a protected bucket doesn't work if it's empty. That's issue number one. Issue number two is most people, if they're not lawyers, lack the ability to tell a good trust from a bad trust. And the analogy I use here is your money, your wealth you've accumulated your whole life is going to take a journey from you to your loved ones. And imagine an Uber is going to take your money on a journey. And if that Uber showed up and it was either the middle car or the left car, no one in your family would put all your life savings in it and move along. But you would get gladly into that Volvo and go, this is a safe vehicle to take me on the journey. We all could do that instinctually. But unless you're a lawyer, unless you're a trust lawyer, you don't usually know a good trust from a bad trust. And so What you need there is you need a financial advisor or someone else you trust to help you select one. All right, let's go through our situation here. We have our same mom, the same asset. She's got her bank account, her investments, her retirement, her life insurance, her home. You'll notice all the beneficiaries ended up being the bucket, not her kids, not her church. Everything is the trust, the bucket. And one person's in charge. You don't have 6 people in charge. And so we say person A is in charge. If they're dead is person B. If they're dead is person C. If they're dead is person D. It's all about contingency planning. If she wants to give money to the Humane Society, boom, they get paid out. No big deal. Let's go through those same problems we had before. Let's go to person 5 first. These are my kids, right? My wife and I want our kids to be wonderful human beings, but not have a third of our money. We have 3 kids, 15, 18, and 20. If we're both dead tomorrow, I don't want them each having a bunch of money. So my brother's in charge, right? He can give them what they need for a place to live and college and meals and a car and even a down payment on a house. But my kids are clearly bucket 5 right now. They can maybe take a third of their money at 25 and maybe the second third at 28. And by 30, I hope they're wonderful human beings grown up with responsible brains and they can have a rest of their money. But those are the rules we put in. Now let's go to bucket 1. If my daughter is in a marriage which is not great, I want her to be able to discreetly, politely, but absolutely legally be able to keep her inherited money away from her spouse, because he may be the greatest guy right now, but he may not always be, and a properly written trust will allow her to do that. Bucket 2, if my son is deceased, and he is a grown up and has a little kid, his money flows down to his little child, the same rules start applying. Bucket 3 and 4, we've got lots of protections for people who have different needs that we want to protect. Any issues you bring to the attorney can be protected. All right, our last 2 documents, financial powers of attorney and healthcare. These are very quick. Financial power of attorney is the document where you give someone the power to be you on financial issues. Without it, a court's involved. And people say, well, what can they do? And I say, anything you can do, almost they can do. I mean, it is unbelievable the power you give someone. And it makes people a little uneasy, which makes them even more uneasy when we get to part 3 here, which is there's 2 types. And if you've done this years ago, I want you to look at yours. The first type is called a springing power of attorney. You will know what it is if it has the phrase, this becomes effective when a doctor determines I'm unable to manage my affairs, or this becomes effective upon 2 doctors, right? You don't want that. You think you might, but the reality is you want the immediate power of attorney. You either trust your agent or you don't. And so if you feel concerned that, hey, if I go to Mexico, my agent has the power to sell my house and close my LPL account. Yeah, they do. I don't want that. My question back to you is, then you don't trust your person, so don't list it. But the reality is the immediate is the right call, because doctors do not like springing powers of attorney because they do not want to sign that authorization. And we all know if you have dementia, your mental capacity goes down. Your family needs to help you earlier on the journey than a doctor will certify. All right. Last thing here is healthcare. This is real easy. 2 parts, durable power of attorney. This is who's your agents. And the second part is you telling your loved one what you want done. These are the unpleasant decisions. No one wants to pull the plug on mom, but it's a lot easier when they can look at the document and say, mom told me to do it. And the gift you give to them by doing it is unbelievable at that time. So, all right. So that's actually going to wrap up the legal side. Everything else starts getting a little more fuzzy. This is now what I've learned in doing it. We're about halfway through. All right. Frequently seen issues. So one of the things your advisor is going to have is this thing right here. It's a handout. I present probably 10 times a year, and I always give this out, and I get feedback later that, oh, there was things on there that were real handy to me. People will call and tell me later. We're not going to hit all 14. We're just going to hit a few of them, but you can get this from your financial advisor. Beneficiary designations everywhere. Check everywhere. If you tell me they're all correct, I'll politely look at you and say, I think you might not be right, because they're not always right. And it may not be your fault. It might be the bank lost them somewhere along the line. The example I gave earlier of the savings bonds in the guy's office in the briefcase, it's a perfect example of why. Double check that. Stale plan. People ask me, when does an estate plan become too old? And the analogy I give is, I hope you have a fire extinguisher at home, but maybe you're like me and you haven't checked it in 5 years or 10 years, because the reality is we don't ever think our kitchen's going to catch fire, but you need it to work when you need it to work. But the reality is your estate plan will work one day. You don't like it, but it's going to work. And so you darn well better double check it. And if you knew 100% your kitchen was going to catch fire one day, I think you would absolutely be not okay with a 20-year-old fire extinguisher hanging out in a cabinet in the garage. You'd say, I think I need to check it. So just be realistic. Also look at it occasionally. Sometimes people don't know what it is, but if your family situation's changed, you no longer get along with your daughter, those are good indications. Real estate issues. I'm shocked how many people are surprised when they don't know how their home is titled. If you and your spouse bought your home years ago and you are 100% sure nothing changed, then I have a high degree of confidence. But if you bought it before you were married, or you refinanced and there was something going on with your business at the time, or something going on with one of your parents at the time, kind of dig deep in your brain. Your house may not be titled the way you think it is. And for a couple $100, you can get a title report. And 95% of the time, it's going to be a waste of money, but that 5% is a real big deal. We see probably 3 or 4 clients a year who are shocked when we start doing their deed work and they're like, oh, crud, I did not realize that. And I'm going to give you an example on this next page, which you're not going to like. We had a woman, and her husband had died probably 20 years ago. Very nice woman. They had one daughter. The daughter's purple. And so after the husband died, he died in his 50s. This woman was in her 70s. And she did a beneficiary deed, a transfer on death deed to the daughter, and everything was fine. Well, about 5 years later, she had been hanging out with a man from her church for quite a long time, and his wife had been dead for a long time too, and they ended up getting married. And everybody is supportive, and her husband, I'll call him Blue, and purple stepdaughter now, everyone's supportive of it. Everything's fine. And that beneficiary deed, the transfer on death deed to the daughter, still fine. The fact that mom married Blue did not change anything, but then everything got screwed up. Mom decided she wanted, and I feel like I'm talking bad about her. I'm not. They wanted a 3-season room on the house, and it was a little house in South St. Louis County. And they went to the bank and they got it. And the bank said, "Oh, okay. Well, we're going to get a home equity loan, but we need your husband to sign." And so he signed. And guess what happened? In that pile of documents, they actually redeeded the house from her to her and him. And I'll tell you this, I've refied about 4 times as the mortgage rates dropped over the 20 years I've owned my house. And they hate me because when I refi, I make them send me everything to read. Well, they didn't read. And they didn't realize that wife and Blue husband here own the house together. And when they did that, it broke the beneficiary deed to the daughter. As bad luck would have it, wife died first. Husband died a couple years later, even though his relationship with daughter was fine. I mean, everything got along. But his estate plan kicked into place at that point, and the house, which he never considered to be his, ended up going to his sister in England. And we found out about it because purple daughter called us up distraught, and our advice to her was, sorry, but it's not your house. I know it was your mom's and dad's for 50 years, but if his sister won't move it back to you, it's not yours. I would take out all mom's personal effects and walk away from it. So that's what happened. Upcoming medical issues. People need to have the courage to have those conversations, whether it is with their spouse or their parents. Jay Leno's wife was losing capacity for years. He had to get a court order to manage her affairs. The yellow wording and the red wording in the middle will break your heart. Unfortunately, she has been progressively losing capacity and orientation to space and time for several years. They should have done something, and they didn't. It should have happened. Your parents' estate plan is your problem, whether you like it or not. Do-it-yourself documents are generally inconsistent. They're wrong. People are rarely funding in properly. We love do-it-yourself documents. We make a lot on probate on the backside, and it's just the ostrich with their head in the sand. Seniors getting married, seniors not getting married. I'm thrilled either way. Think through it, but you got to plan for the survivor if you're not getting married, and you got to plan for Medicaid if you are getting married, and there's an imbalance of money between the two. Our last one on here is additional names on the account. You really got to watch it, and I said that earlier, and I have a horrific example of where a mom had most of her money in a bank account. I'm sorry, most of her money was in the house. She had very little in savings, and she had her son on the account. And she told me, she says, it's fine. It's fine. I only keep 5,000 in there anyway. Well, she had 3 boys. Well, she sold the house. The 600,000 fell into the small bank account. And before it was transferred to her financial advisor, she died. And the one son who's named on the bank account kept the money. So he ended up getting about 600,000 of her 700,000 total net worth, and his 2 brothers are mostly left out. So people sometimes change after people die. All right, our last 2 here. If you guys are still hanging in there, you're doing good. Young adults. For me, when my kids turned 18, it was kind of another birthday, right? They could vote, they could buy lottery tickets, they could legally contract, but in the eyes of the law, everything changed. I knew it because I'm an estate planning attorney, and I quickly whipped out a very simple estate plan they made fun of me for. There's financial issues. If mom or dad are not on the bank account, really the bank won't deal with them, which is trouble. And medical providers don't really need to deal with mom and dad either. Now, is that big of a deal? No. Usually medical providers will. They don't have to. My nephew was in a car crash, and his mom was told by the hospital they wouldn't talk to her, and she was horrified. Rightly so. He was just 18. So the solution is a simple will, a simple healthcare power of attorney, a simple financial power of attorney. And I tell people, have your 18-year-old do it. And then when they get married at 25 or 30, then they'll replace it with their spouse. You can find these online inexpensively, or some law firms do it. We do a real inexpensive plan, but just do something. All right, we're knocking this out. All right, we're up to the last part. Sometimes I struggle with this last part. This is me. This is 3 years and 5 days ago. And I got the news. Actually, my surgery was 3 years and 5 days ago, and that dark spot at the bottom is not supposed to be there. And I was having issues in the fall of 21 with some memory lapses, and the doctor thought it was just like low blood pressure. They started ruling some things out, and horrified to find out that I had a brain tumor in what is the worst location possible, with a terrible appearance that they were afraid was terminal. And the only option forward was a surgery that had a good likelihood of not surviving. And that was exactly 3 years and 5 days ago. Or if I survived, I might not know who my family was or lack basic bodily function. And so, as you would expect, that knocked me on my feet. And as I mentioned, I was in my 40s, and I had married for 20 years and 3 kids in high school and grade school. About 4 days later, I was in my bedroom crying. And my wife came in, and she gave me, and she knew, of course, what was going through my head. And I said, I understand that people die. And if it's me, it's not the worst thing in the world. I know kids die. It's better me than our kids. And I know it happens all the time. But it's unfair that there are child abusers and horrible people out there that aren't going to be impacted, and they'll live to their 80s, and I'm going to be dead in my 40s. And I love my life, and I love my wife, and I love my kids. And I don't want to leave. And her answer was fantastic. She said, "It is unfair. And your path forward is probably not good. But you really only have two options, and they're up to you. You can either sit here and cry, and no one will fault you, but your kids will watch that. Or you can knock the heck out of this, and people will be surprised, and your kids will watch you." And she left. She went and ran errands, which seems pretty heartless, but she was right. And she nailed it as a spouse, because about a half an hour later, I thought she's right. And so it kicked in. And the next day I went to work and I told my team, I said, we're going to really do a good job. We're going to go back on the thousands of people we've worked with, and we're going to figure out what went well for their families and what didn't go well. And I'm going to do a good job for my clients and for my kids and for my spouse and for my family and for you guys. And we're going to do a really good job on me checking out. And I got 5 weeks to do it. And we did. We really worked hard, and we got all the clients wrapped up. We communicated with everybody, and there was no loose ends, and I rolled into surgery. And the morning of the surgery, we're sitting there, and I told my wife, I'm like, I need my picture. Get my last picture before they roll me off, because they told me they were coming for me. And she got my picture. And about two or 3 minutes later, the surgeon came in, and he was about ready to go. And he starts looking at my head. And this is funny, and I'm telling you this to bring it back to some normalcy. He's looking at my head, and he's looking both ways. And I'm at Barnes, and I mean, they're amazing there. And all of a sudden, he pulls a pen out of his pocket, and his head just keeps going back and forth as he's looking. And he starts drawing on my head. And then he said, "All right, we're ready to go." And he walks out. And I said to Claire, I said, "What'd he do?" And she goes, "I don't want to tell you." I go, "What'd he do?" She said, "He wrote the word yes on your head." We both started laughing because it seems pretty ridiculous. And I said, "You got to replace my picture with this as my final picture, because it's ridiculous." And that might have been one of the best things that ever happened in that whole period, because it just completely broke the tension. So, but clearly I lived through it. Whatever reason, 12 hours later, they woke me up, and it was not cancerous, and it has not grown back. And I'm the luckiest guy on the planet, and I'm as happy as can be. And about 6 months later, I was asked to speak at a national conference of financial advisors about what I learned, because of my unique perspective, being an estate planning attorney who spent 5 weeks preparing for his own likely certain death. And I made a flyer front and back, and it lists everything we did that I thought would be valuable to other people, from banking to legal documents to real estate, to what you do with your spouse, and just kind of what I learned. And it's on my website, and every slide has my website on it, or you can get it from your financial advisor, and your financial advisor is going to have this too. And I really encourage everyone to go through this and try to do some of these things in their own lives. And so we're not going to go through the whole thing, but here's a few examples, and this is my last slide. And these are all things I was screwing up. Prepare a master list of all your financial institutions so that your follow-on helpers can know it. I wasn't hiding anything from my wife, but some of the things changed. All our money was at LPL, but we had some small bank accounts at some other places, and she was on there, but everything's electronic statements. She wasn't paying attention to them. So, we always just keep everything updated now. Number 2, bank accounts for minor kids. Usually only one parent's on there. I was the only adult who had the authority to access those, because I set them up when my wife was recovering from C-sections. And when I tell clients that, almost everyone's the same way. Only one parent's on there. That would have been trouble. Number 3 on here. I don't know why I had the ability to pull this one off, 3 and 4, but after I got the phone call from my doctor that things were really bad, my first call was to my wife, and my second call was to my LPL advisor. And I called and I got his assistant, and I said, I act like I said it real calm. I was bawling, but I said, I need two things from you. One, I'm going to send you my power of attorney. And I need to know that for the rest of my life, no matter how long, if I'm stupid, that you're going to honor it and you're going to listen to my wife for everything. And she had it on file, and they took a look at it and said, you're good forever. And then the second thing I did was number 4 is I said, I need to make sure that my life insurance is on auto pay because my life insurance is through LPL. And she said, you're good. Because I surely couldn't have a lapse in coverage, right? Because Claire doesn't know about it, and it lapses. So, and then do that with all your bills if you can. And then number 5, and this is something that I think would have been valuable to my family, but I am horrifically made fun of for now, was I went through the house with my camera on my phone, and I just made list of everything that I knew that no one else knew. And they call them Dad's dork videos now, which I still love. I think they would have liked them if I was dead, but I mean, think about it. Everyone on this call knows things that their spouse doesn't know. And if you can write those things down, or you could leave some notes, it is a wonderful gift that you're giving to other people that you love. And so I would encourage everyone to do that. So there is my contact information. And Bill, I will turn it back to you.
Scott, this is the second time I've gotten choked up on a webinar. And the first one also happened to be with you when you told the same story. Of course, we're very happy you're here. And I'm glad I had a few slides to pull myself back together before I came back on camera. So I appreciate that. I did see a couple of folks while this was going on. I did see some folks use the raise hand function in Zoom. There's really no way for me to ask your question or answer your question because, again, the chat feature is turned off for this webinar, and that's for compliance purposes. This is, by the way, being recorded, and it will be available. Your advisor will get a copy of it as soon as it's ready to go. They'll have the link. If you want to watch this again, if you want to send this out to a friend, someone that you feel would benefit from hearing what Scott had to say today, I think that's a great thing to do. If you do have questions, I'll go back to where I started with that. You have to email those, and the email address is cornerstonewm@lpl.com. And those will come to me. I'll ask the question to Scott on your behalf. But again, cornerstonewm@lpl.com. So please fire those away. Scott, I have a couple as we're waiting for some questions to come in. And you mentioned the titling of homes. And I'm kind of putting you on the spot with this one, but I expect you're probably going to know a little bit about this. Of course, you're starting to hear a lot on TV. They're advertising these services of protecting your home, or like this home title lock kind of thing. If you title your home in your trust, does that provide maybe an additional layer of protection from someone trying to steal your home through title theft?
In my experience, it does not.
Okay.
And I do not pay for the title lock. I don't think it's needed. The reality is, I mean, it is your home, and if someone fraudulently transfers it, it's still your home, right? And so you generally start seeing some red flags. If you're not paying property taxes and not paying attention, then there's a problem. But whether it's in your name or your trust name, it's still your house.
One other one that I'll ask, and while we're waiting for some other questions to come through, I love how you use the terminology of having things really planned out, have a well thought out estate plan, the communication to the family, how much of a great gift that is to those who are being left behind. And you talked, of course, about the those medical directives, and kind of helping the children make decisions, or helping the loved ones make decisions that would be very tough to make on their own, but you making them for them. I may have shared this with you before, but estate planning is something that I am a bit passionate about. I had a personal example with this where we had a family farm. It was my great grandparents' family farm. They had 4 children. All 4 children got along very well. And of course, they didn't do any estate planning. It just passed to the 4 kids. Everything was fine, but the 4 kids have spouses. The 4 kids then start to have kids and grandkids. And what started off as a very easy solution of it's just going to pass to the 4 kids. Now you have 8 people, 16 people, 20 people involved in that decision-making process along the way. And needless to say, there's a lot of family members that I unfortunately don't see on a regular basis anymore because it created turmoil in the family. So, beyond just the legal aspect of transferring the document or, transferring of the assets, there are those personal relationships that I think people probably would want to maintain if they could give their loved ones that gift. And I'm sure you see that all the time.
Yeah, family farms or vacation properties are one of the more tricky things we deal with because there's so many emotions tied up in them. Um, I had a um, I had a client early in my career, and he broke my heart. Uh, his dad had hunting property, and everyone used it, and they used it for years. And then his sister ended up moving away up to Washington State, and the dad was talked into doing a trust that would hold the family farm forever, which we don't do because forever is a long time. And he used the phrase about his sister, which broke my heart. He said, "My stupid, greedy sister wants to dishonor my dad and sell the farm." But the reality is, she lives in Washington State. She's a secretary, her husband's a laborer, and they have a special needs kid who costs a fortune every year. And he's using it as his farm property, and it's worth a few $1,000,000. And so um, we we tell people, if the farm was someone else's at one time, and it's going to be someone else's eventually. So forcing your children to either sue each other or hold it forever is not a great idea. There are a lot of options we could do on that. But as you mentioned in your family, just logically work through those. Don't just leave it.
Yeah, let them be mad at their parents one more time when their parents are dead, but at least they still get along as a result of
Right.
it.
Exactly right. Or at least allow some outs, right? There needs to be an escape clause. We've done it before where if 60% of the people want to be out, then the family farm needs to either be bought by the other people or sold.
Scott, really appreciate your time today. This was fantastic. As you mentioned, you have 2 handouts that will be available along with the recording that I mentioned before. I would just set the expectations on that. Typically, these things take about a week or so before we get them out to the financial advisors, but they should have that ready to send out to everyone if you'd like a copy of it. And we'll be sure that that those materials are made available as soon as possible. But Scott, really appreciate your time. Really appreciate all of your knowledge and your amazing personal story that you bring to this very sensitive topic. And I think it brings it home for everybody. So again, thank you so much.
Thank you, Bill. Appreciate it.
All right, have a great day, everybody.
Bye-bye.
Bye bye.